Good day. We are Group 7 here to present GR number 171460, dated July 2007, Mercado versus Allied Banking Corporation. The petitioners are the heirs of Perla Mercado, namely Lilia Mercado, Cynthia Ficares, and Julian Mercado Jr. The respondent, on the other hand, is Allied Banking Corporation, an authorized banking institution. For chronological timeline of events, it started on May 28, 1992, where Perla, the mother of the petitioner, executed a special power of attorney in favor of her husband, Julian Mercado Sr., over several pieces of land and personal property under her name. On March 10, 1993, Perla revoked the SPA she had given to Julian. On December 12, 1996, Julian obtained a loan amounting to $3 million secured by real estate mortgage constituted on TCT number RT 18206 10338, registered with the Registry of Deeds of Quezon City, using his authority as SPA. On February 5, 1997, Julian subsequently obtained an additional loan from Allied Bank in the sum of 5 million pesos and still used the same subject property as of security. However, Julian defaulted on the payment of his loan obligations. Hence, the respondent initiated extrajudicial foreclosure proceeding over the subject property. Before continuing on what happened on the timeline, we would like to discuss and clarify the current issues. First, Julian used his authority as SPA even though it was already revoked by Perla 6 years ago. Second, even though Perla gave Julian ownership on various lands in the initial SPA contract, the Registry of Deeds in Quezon City was not one of them. Hence, Julian had no authority whatsoever to claim ownership on the land he used as security. Julian later defaulted his payments, which resulted in initiated extrajudicial foreclosure proceedings by the respondent over the subject property, in it being auctioned wherein the highest bidder is the Allied Banking Corporation itself. To continue the timeline of events, on January 15, 1998, the property was sold in auction and acquired by the respondent. On March 23, 1999, the petitioner sought legal action on the Regional Trial Court to annul the real estate mortgage. In the legal action sought by the petitioner claimed that, first, secured land was not covered by the SPA. Next, Julian had no authority due to the SPA revocation on March 10, 1993. And lastly, Perla's requirement of full consent for another to sell or mortgage her property. The respondent, on the other hand, claimed that the error lies within the SPA contract itself. The respondent believed that Perla intended to include the debated parcel of land, which is the land with the Registry of Deeds in Quezon City.
On September 23, 2003, the Regional Trial Court rendered the decision declaring the REM constituted over the property null and void, as well as the foreclosure proceedings and auction sale. The court ordered that the foreclosure proceedings and the auction sale conducted pursuant to the void REM be nullified. The respondent, however, was not satisfied with the decision and petitioned the Court of Appeals, in which the court ruled in favor of the bank. As the Court of Appeals reversed the decision, the petitioner raised the following concerns. First, whether or not there was a valid mortgage constituted over subject property. Respondent tried to argue that Perla intended to include the parcel of land in SPA despite the error. After reviewing the SPA, there was no indication or reference to the said subject property. Second, whether or not there was a valid revocation of the SPA. Revocation of SPA expresses through public document in March 10, 1993. Third, whether or not the respondent was a mortgagee in good faith. They should have exercised extra precaution when dealing with land purchase without the actual owner. The petitioners, unsatisfied with the reverse decision, took the case to the Supreme Court, wherein the results of the case are as follows. First, the mortgage is unenforceable. Second, foreclosure and auction is null and void. Third, respondent is not deemed an innocent mortgagee. Fourth, respondent is within the right to proceed against Julian himself. The mortgage is unenforceable because Julian was revoked his SPA rights. Therefore, Julian is unauthorized, hence making the real estate contract mortgage unenforceable. Hence, the foreclosure and auction is null and void. The respondent is also not deemed as an innocent mortgagee because, as the court states, as a banking institution, jurisprudence stringently requires the respondent should take more precautions than an ordinary prudent man should to ascertain the status and condition of the properties offered as collateral and to verify the scope of the authority of the agents dealing with this. This, however, does not mean that the respondents cannot proceed against Julian himself for the loan payments. In conclusion, the decision of the court is as follows. Wherefore, in view of the foregoing, the instant petition is granted. The decision dated October 12, 2005, and its resolution dated February 15, 2006, rendered by the Court of Appeals in CA-GR CV number 82636 are hereby reversed. The decision dated September 23, 2003 of the Regional Trial Court of Quezon City, Branch 220 in civil case number Q9937145 is hereby reinstated and affirmed, with modification that the real estate mortgages constituted over TCT number RT1826 are null and void, but unenforceable, no costs. Thank you for listening.